morning, Your Honor. May it please the court, my name is Matthew Dowdy with the Tennessee Attorney General's Office, and I represent the University of Memphis. I'd like to reserve 4 minutes for rebuttal.
4 minutes. We've gone from 5, 4, and 3 this morning.
Hidden for the cycle. Your Honor, we are asking this court to reverse the Chancery Court and to uphold the university's termination of the appellee Cedar Nordbye for capricious disregard of accepted standards of professional conduct under Tennessee Code Annotated 49.83025. I'd like to focus on 2 points in my argument today. First, why the university proved adequate cause for termination by clear and convincing evidence. And second, why nothing in the pre-termination procedure justifies reversal of its decision. Unless the court prefers otherwise, I'll start with the evidence supporting adequate cause. As outlined in our brief, from 2015 to 2017, Mr. Nordbye engaged in a sustained pattern of disruptive, combative, and at times threatening conduct towards students, colleagues, and administrators. Conduct that he himself has described as, quote, toxic, childish, and immature. When the art department chair, Richard Liu, initially attempted to address these issues, Professor Nordbye often dismissed and mocked his concerns, and over time, his responses escalated into open defiance and hostility. Many of these exchanges I'd like to note between Professors Liu and Nordbye occurred via email, and those emails are included in volume 3 of the record, starting at page 346. The record also clearly demonstrates that Professor Nordbye knew that his conduct was unacceptable. In early 2016, Professor Nordbye wrote to Liu that he intended to, quote, put a period of my belligerence behind me. In early 2017, when that commitment did not materialize, the university assigned another faculty member to mentor Professor Nordbye in, among other things, conflict avoidance. Although Professor Nordbye agreed that he would benefit from that arrangement, and he agreed with the selection of his friend and longtime colleague, Michael Schmidt, to serve as his mentor, his conduct did not improve and in fact got worse. And Nordbye acknowledges that when the university placed him on administrative leave in April of 2017, he knew that he risked termination, and he asked Professor Liu what he needed to do to keep his job with the university. Liu responded, quote, listen to me. Even so, when Professor Nordbye returned from administrative leave in the fall of 2017, he picked up where he left off the prior semester. In August of 2017, the university placed Professor Nordbye on a performance improvement plan to address deficiencies in both teaching and misconduct, and warned that his failure to adhere to that plan would result in termination. Just weeks into the semester, and just weeks after he was placed on that performance improvement plan, Mr. Nordbye removed a sink from the wall of a classroom without permission. Later in an email to Professor Liu, he admitted that he knew removing the sink was crossing a boundary at the time that he did it. He nevertheless argued vehemently with Liu that he could alter the space however he chose, and admitted to Liu that he removed the sink out of anger and as a way to regain control in their relationship. Soon thereafter, Professor Nordby's faculty mentor, Michael Schmidt, resigned from that role, citing concerns not only about the level of Nordby's expressed contempt for Liu, but also how his anger had spread to other colleagues in the art department. And so that is sort of just a broad overview. Our briefs go into a lot more detail, but that's a broad overview of the pattern of unprofessional conduct, and in particular, the fact that the conduct continued despite repeated interventions, warnings, and acknowledgments that supports the termination on the capricious disregard ground. The Tennessee Supreme...
The faculty hearing committee
Yes.
disagreed, correct? Or whatever you want to call them, the hearing panel? hearing panel disagreed and said he needed to be given an opportunity under some improvement plan. I'm not using the right nomenclature here, but to see if his teaching would get better, because that's what they believe should happen. Why is that wrong?
Well, the faculty panel was relying on a separate section of the faculty handbook. That section contemplates a 3-year process before a professor can be terminated for adequate cause based on incompetence in teaching or failure of professional excellence. But the faculty handbook expressly states that those provisions do not apply to termination based on capricious disregard. It is just those two grounds, the incompetence in teaching and the professional excellence ground, that those provisions would apply to.
What did the hearing panel, the faculty panel, say about the capricious disregard element?
To the extent that it addressed that element, it considered these incidents in isolation. It also relied heavily on the performance improvement plan and its understanding that that required a 3-year process. In addition, this is a de novo review. It's sort of a niche level of review as far as current Tennessee law. It's a whole new hearing in the Chancery Court, and so the panel's decision is not entitled to any deference on that level of review.
Well, let me take you to the next step then. The president of the university disagreed with the hearing panel and decided termination was appropriate. Can he do that? Can he overrule the hearing panel?
Yes, Your Honor. The faculty handbook is clear on that point. It says that the university president can make, quote, the final decision regarding termination. And in fact, it expressly contemplates that that final decision may be contrary to the faculty panel's recommendation.
Well, the second question I have is this. I'm looking at what it purports to be the letter. Does the president, if he disagrees with the hearing panel, have to provide his findings, his conclusions? Because you've got a fairly extensive hearing panel order in which one party dissented. Then you've got a page that doesn't say a whole lot other than you're terminated.
Yes, the faculty handbook says that the president, if his decision is contrary to that of the faculty panel, has to provide a statement of the reasons. And so that is what is reflected in that letter.
You think that's reflected in that letter?
It is a statement of the reasons, and it is it closely tracks the analysis of the sufficiency of the evidence in the Phillips case that we've cited, the Supreme Court's 1993 case in Phillips.
So you think it's sufficient?
Yes, and I would reiterate also that the decision of the university, both the faculty panel's decision and the president's decision, are not entitled to any deference on de novo review. It's a whole
So once
new
it goes
hearing.
to Chancery, it's a brand new,
That's correct.
and we're reviewing the chancellor's
Yes, Your Honor.
decision.
Yes.
All right.
It's in Cooper versus Williamson County. That's one of the cases we've cited in our brief. That was a high school principal with tenure, but at that time, I believe until 1992, it was the same standard of review, and they likened de novo review in this context to an appeal from general sessions to circuit court, albeit with a record. The court doesn't have to hear all the evidence again. It has that hearing record. But what happened during the administrative hearing is not entitled to any deference. In the Phillips case that I mentioned a moment ago, the Supreme Court squarely addressed the capricious disregard standard ground for termination, and that case is directly on point, if not controlling here. In Phillips, the court upheld the termination of a professor at Shelby State Community College not based on any single incident, but on a sustained pattern of misconduct over a period of 3 years. Specifically, the court noted that the professor exhibited unprofessional conduct towards students, colleagues, and staff, students, faculty, and staff, insubordination, and an unwillingness to improve after repeated warnings. The court also noted that the department chair attempted to mediate these incidents with the professor, and that those meetings became adversarial to the point that they had to be discontinued, and that these incidents continued even after the professor was warned that she risked termination. The court held there in Phillips that considering the entire record, the capricious disregard ground was established by overwhelming, clear, and convincing evidence. And in doing so, it emphasized that tenured faculty are expected to behave professionally towards students and coworkers and to comply with the directives of a supervisor. It also noted that tenured professors can use common sense and general knowledge of employer-employee relationships to ascertain the behavior that risks termination on that ground. And I see that my time is up.
You still got 4 minutes.
Good morning.
Good morning.
Maureen Holland, along with Yvette Kirk, for Mr. Cedar Nordbye, who's in the courtroom as the appellee. This case is about delay by the university, who has already been ordered by the Chancery Court to reinstate Cedar Nordbye and pay back pay. There was even a motion to grant a stay. The Chancery Court said no, because an appeal would not be with merit. There was no merit in this appeal, according to the Chancellor, who reviewed this case at great length. And I'm going to explain why there's no merit in this appeal. Immediately, I want to address the assertion that the 3-year performance improvement plan, which you're supposed to be put on if you're a faculty member and you're failing, somehow specifically it doesn't include capricious disregard. It's not, actually doesn't say it doesn't include capricious disregard. It says, as many things do, it applies to this and applies to this, and it doesn't say what it doesn't apply to, but it says it applies to teaching and it applies to professional excellence, which actually is what we're talking about, professionalism. And the university tends to, when it loses under a category that it has asserted, it tries to change the category and assert its claims under a new category, and fails again. So I want to just give an overview of what this case is. There was a professor who was tenured in 2009, and he was subject to, and I'll list the 4 main events that happen that the university now contends are a problem. He was arrested in connection with a domestic matter. That arrest was dismissed in the domestic matter. He was placed on a performance improvement plan, which is what you are to be placed on if you did not do well, and he did not do well in his 2015 assessment, and therefore you're supposed to be put on an improvement plan, which he was. The events that they allege, all these events happen prior to be putting on an improvement plan. The only thing that happens after he's put on an improvement plan, which results in his termination, and initially a summary termination for which there was a federal court case, for which there was an agreement, and he came back for a hearing. But the only event is that he removed a sink from the classroom. Now, the record is really clear about what those classrooms were like and the problems going on. There were huge problems with the classrooms. They were not well kept, they were not maintained, and that particular classroom, the maintenance had come in, removed items, left holes in the wall, which Cedar Nordbye fixed, and there were 2 sinks, and he took out one of the sinks, carefully putting it onto the side, no damage, covered it up,
If he felt
and
great about the sink situation,
Yeah.
why then is he doing a mea culpa and saying afterwards, that was a boundary line that I crossed and I did it because I was mad at, I can't remember if it was Lou or,
Certainly, there was a statement by Schmidt who says that that's what he was told, and that he was mad, and that's some of the evidence in the case, but there is also countervailing evidence in the case that that's not entirely what was going on, which is what the committee heard, both sides. Schmidt says he was mad, he was confessing that he was mad. Employees get upset and frustrated and mad. That's not a terminable offense.
if they have a history of getting upset and mad all the time.
Well, in this particular case, Professor Schmidt has a long history of being upset and mad. Professor Close, as you know in our brief, says Professor Schmidt's a bully. That's the mentor, by the way, that he was assigned. Professor Schmidt uses profanity. Professor Schmidt engages in this wrongful behavior. The particular art department, which is what the committee heard, had a lot of issues going on at the time. Professor Close and Professor Jenkins, also members of the faculty, said that they felt that what was going on is the art department was having a general issues, and that had to do with the leadership of the art department, Professor Liu, who was the chair, and that's really what was going on. And to whatever extent, and it's true that Professor Nordbye was having issues related to his divorce, and there were problems, and he admits that there were problems, those problems never rose to the level of meeting the criteria, which is what the university has to prove, which is their burden, that they have to prove by clear and convincing evidence they're sufficient to warrant termination. The handbook is quite clear. The handbook is clear. It's based on state law. So this case is whether or not, in reality, whether or not state law requires the university to follow the handbook and requires the university to follow certain basic things. Number one, is the university required to issue a decision of termination based on the record? Here, the president, in his letter and in his conduct, did not terminate Professor Nordbye based on the hearing record. There's an admission that he
Just
didn't.
let me clarify, we're not really reviewing what the president did.
You're reviewing, well, insofar as the Chancery Court directs that what the president did violates state law, yes.
But ultimately, the Chancery Court said, I don't think there was sufficient evidence presented to show that Professor Nordbye showed a capricious disregard for professional standards. Is that not what we're reviewing?
You're reviewing.
That decision?
You're reviewing, there are two pieces to this case. One are all the facts. And at the trial court, there were 4 main categories of facts with many subsections. All have been waived by the university except for the capricious disregard on appeal. But at the trial level, they were all discussed by the chancellor, who on every single category, on every single subcategory, found in favor of Cedar Nordbye. Every category, on every fact. The law, so under the facts and the totality of those facts, the chancellor said there is not, the university has failed to meet its burden under the law of this very high burden, if you're a tenured professor, the high burden of clear and convincing. But there's a second part. And the second part that the chancellor also addressed was state law. State law says that you cannot, you're prohibited from firing, not just the facts, and that win on the facts, true, completely, that's a win. There's a second win, though, on the law. not just the law of totality, but the law of did you follow the statute? They did not. They admit they did not. The only evidence in the record is the president issued a decision not based on the facts in front of the committee. That is not just a failure to meet the standard of clear and convincing, but it's specifically listed as a statutory requirement under state law. So the statute says, basically, you cannot be terminated unless there's a record, and I can, that is under 3, I will get that for you. (49.8.303). So 49.8.303 says these are the procedures that you have to follow before you can fire a tenured employee. There has to be a record under subsection 3. Under subsection 4, there has to be the burden of proof that adequate cause for termination exists shall be upon the institution by clear and convincing evidence. Number 6, the findings of fact and decisions shall be based solely on the hearing record. Well, that didn't happen here, so the chancellor's like, if you don't follow the state law, then you don't have a merit appeal. And that did not happen in this case. The second thing that did not happen in this case, which Judge Stafford asked about, was that letter by the president and whether the president had authority to basically disregard the panel. And the answer is no. No, the president does not have the authority under that handbook. That particular handbook at the University of Memphis is an agreement, and this is in the decision by the hearing committee. It outlines this because it's directly from the handbook. I believe it's page 97. It's an agreement by both the faculty and the administration as to how the procedures work for tenure and for tenure removal at the university. And you have to follow this handbook. State law says promulgate a handbook. They did, then that handbook must be followed. That particular handbook is very specific with authority. Who has the authority to make a determination as to adequate cause? And it vests that authority in the president's panel.
I
Now-
believe your opposing counsel argued that those provisions do not apply when you're looking at a situation of arbitrary and capriciousness.
Absolutely false. Those provisions apply. The hearing process applies as to whether or not who makes the determination of adequate cause for all of the topics under the handbook. That handbook, which is, I believe, now volume 10, and it's page 40 under volume 10, but the entire part of that is set out on page 6 of the committee's report. And it's very important, page 6 of the committee's report, because it outlines the process, state law. It sort of takes you through these steps of understanding how this process works. And it says this: a hearing shall be conducted by the hearing committees, also known as a president's panel, to determine whether adequate cause for termination of the faculty member exists. That's the purpose of that committee. They fulfilled their purpose and said 3-1, there is not adequate cause for termination, even under capricious disregard. Not. No. The university wants to rewrite this. They want to say the president is to determine adequate cause. Well, that makes no sense. Why does that make no sense? It's quite simple. I'm a civil rights employment lawyer. When you're an at-will employee and you're working for, let's say, a company or even the government, and you don't have any protections, and we say, you're fired. I don't have to have a reason or a good reason, just goodbye. You're done. I make the decision. I can prosecute the removal. Tenure is different. tenure doesn't allow the president to both say, I want to remove you, and I've decided that the removal is fine. Because you're no longer an at-will employee, you have protected rights, which is why the whole construct was set up.
So it's your position that once the if the panel decides no adequate cause,
Yes.
the president cannot cannot overrule that essentially.
Right, and it says, so what they want you to read, under the subsection in the handbook 9, which is on page
So
7
what
of...
can the president do? Nothing.
The president can do, the president can take other non-dismissal steps. I want to, there is discipline less than termination. Suspension is contemplated under the handbook.
But under what grounds would you discipline someone if there's no adequate cause for a finding of?
Maybe you shouldn't, because you can appeal even a suspension under the rules. So, yeah, maybe there's nothing for the president to do, but that's the whole point, is that the president doesn't get to decide at what point in time I think they deserve to be fired, but the panel says they can't be fired, and the panel is vested with the authority to make a determination of adequate cause, and it says, additionally, just because maybe saying it once isn't enough, say it twice, and that's better, that you have to, the committee must, when it writes to the president, say that they're, provide the findings of fact, and say whether or not we, the committee, have determined adequate cause. The recommendation language under subsection 9, where the president can do things that the committee recommends, never uses the word termination. And I was reading, I like Latin, studied Latin, hope to use it sometime on occasion. Not so much anymore in the law, but I saw it in the case of Wells v. Tennessee, when they're looking at statutory construction, 231 Southwest 3rd, and I see I have 1 second. May I just read this one phrase?
Go ahead.
Thank you. It says this: when considering the meaning on a statute, the court may employ the Latin maxim, and I hope I get this right, express unius est exclusio alterius, which means the expression of one thing implies the exclusion of things not expressly mentioned. Expressing the determination of adequate cause to the committee, not providing that authority to the president, and saying only recommendation to the president is an exclusion under that maxim. We request that you affirm the chancellor's ruling and provide for all reinstatement benefits and any other relief required. Thank you so much.
Thank you. Mr. Dowdy, you got 4 minutes.
Regarding the president's authority under the faculty handbook, the distinction between the faculty panel's determination and its recommendation, that's a distinction that does not exist in the faculty handbook. The faculty handbook says the president makes the final decision with regard to termination. There is no language in there that suggests he is bound in any way by the faculty panel's determination, recommendation. It expressly contemplates that he may reach a conclusion, make a decision that is contrary to what the faculty panel's majority has decided. In addition, the petitioner deposed the university's 30.026 witness, Dr. Tom Neenan, who was the university's provost at the time, about the procedure used in terminations. And Dr. Neenan testified that all faculty panels at the university are advisory. The president always retains final decision-making authority, and that he cannot delegate that authority to a faculty panel. And in addition, I would note that Tennessee law expressly permits this structure under TCA 49.8303B. The termination procedures adopted by a state university, quote, may provide for review of the committee's decision by the board or its designee based upon the record. The university has adopted that structure that is expressly permitted, and the president is the board's designee to make that final termination decision. With regard to information that the president considered in reaching that decision, again, that is cured by de novo review in the Chancery Court. The Cooper case talked about that specifically in the context of a school board and said it stands to reason that the school board would be aware of issues with a teacher before that teacher's case comes to it, and that is precisely the reason for de novo review. There is no way to seal the president off from the rest of the university and keep him from learning about what is going on at the university. That is his job to know. And in addition, I should note, there is no evidence in the record that he considered anything outside of that faculty hearings record. Turning back to the substantive merits of the case, just like the professor in Phillips, Professor Nordbye here was expected to behave professionally towards students and coworkers and to comply with the directives of his department chair. And just like in Phillips, Professor Nordbye violated that expectation not because of any isolated incident, but because he engaged in a prolonged pattern of disruption and insubordination that continued despite repeated warnings and his own repeated acknowledgments that his conduct was not acceptable. The Chancery Court erred by considering these various incidents of misconduct in isolation rather than the cumulative weight of the evidence considered as a whole, which is precisely the opposite of what Phillips instructs the court to do. This is not about a single lapse in judgment. It's about a pattern of unprofessional conduct that no reasonable employer should have to tolerate. Professor Nordbye had ample notice and he failed to adjust his conduct. And just like the professor in Phillips, the record here contains overwhelming, clear, and convincing evidence to support his termination on the capricious disregard ground.
Thank you. Thank you, counsel. We will review the record, take this matter under advisement, and attempt to get you an opinion at the earliest possible time.
Thank you.
I believe that concludes the call to the docket for this morning. We'll stay in recess to the afternoon docket.
All rise.